Further hearing the appeal of the Queen on the application of Maughan against Her Majesty Senior Coroner for Oxfordshire.
Yes, Mr. Hoff.
My lords, my lady, at the end of yesterday I just finished setting out the arguments in favour of the civil standard of proof applying to suicide conclusions. The remaining topics I have to address are, first of all, the arguments in favour of the criminal standard applying, and secondly, importantly, the standard of proof for the unlawful killing conclusion. Before I do so, may I deal briefly with the Inquisition form schedule to the 1984 rules. Each of you should have on the bench a small clip headed with the name of that statutory instrument. The first 3 pages list the contents so that you can see what in broad terms the rules covered. The 4th page, which has 1709 in the top right, has been reproduced because it contains Rule 60, which is the rule stating that the forms set out in Schedule 4, with such modifications as circumstances may require, may be used for the purposes for which they're expressed to be applicable. It means that the Inquisition form we're about to consider was not mandatory, although it was in fact generally used. The final 2 pages are from Schedule 4, in which Form 22 was the standard Inquisition form. And you may wish to read that alongside MS 846 at Authorities 1 divided 2, which is the current record of inquest form. That's the last page under divider 2 of the first Authorities bundle. And if we make a comparison, we see that the item 1 is the same, identity of the deceased. Item 2 has changed from injury or disease causing death to medical cause of death. And as we'll see, the current form requires that to be used generally, whereas the form schedule to the 1984 rules required it to be used only in certain circumstances. Item 3 has changed from time, place and circumstances, at or in which injury was sustained, to how, when and where the deceased came by his or her death. And again, we'll see that the current rule requires that to be generally used, whereas the previous rule suggested that it be used only in certain circumstances. Item 4 is the same, conclusion of the coroner or jury as to the death, subject to notes. Item 5, death registration particulars, is worded slightly differently, but is in substance identical because the death registration statutory provisions remain the same. Over leaf are the notes. Note 1 simply says that the form is to be modified as necessary depending on whether it's a coroner or a jury completing the form. Note 2 says that the entry at item 2 for injury or disease causing death is suggested for use only in certain cases. In short, cases of natural causes, disease or drugs. Note 3 says that the entry at item 3, so that's the entry for time, place and circumstances, is for cases where Note 2 doesn't apply. So that's primarily for sudden and violent deaths. And then Note 4, which is the longest, suggests that the entry at item 4, conclusion as to the death, should be completed with one of the short form conclusions. And they are divided into categories A, B, C, and D. A, various short form conclusions where Note 2 applies, so natural causes, disease and drugs. B, a series of short form conclusions appropriate to sudden and violent deaths other than murder, manslaughter, infanticide or stillbirth. 4C, the unlawful killing conclusion, which was introduced into these rules for the first time, as I said yesterday, and D, stillbirth, which doesn't involve completing the remainder of the form because a stillbirth is not regarded as a death. And my lord and my lady might also note from the explanatory note that these rules consolidate with minor amendments the prior rules of 1953.
I don't think we have.
We're not concerned with.
I don't think we have the explanatory note for the 2013 rules, do we?
I think that was added into the black file that was supplied yesterday at divider 8
yes.
at the explanatory memorandum.
Thank you very much.
Now, what will be obvious is that the notes to the 1984 rules said nothing about standard of proof. It will also be seen generally that the revised version of the form in the 2013 rules has a number of features in common with the prior form, but it's been updated evidently to provide a simpler and more accessible record of the jury's conclusions.
When you said the explanatory note,
Yes.
to the up-to-date rules are in tab 8,
Yes.
were you correct? Or was it in tab 7? And is not the explanatory memorandum something slightly different, Mr. Hoff?
My lord, you are quite right. The explanatory memorandum is different.
Yes.
The explanatory memorandum has been provided in relation to the 2013 rules. The explanatory note, I don't think, is in Authorities 1 Divider 2, but Ms Monaghan helpfully tells me that she and Mr Bunting have brought copies of that to assist the court, and she'll address that in her.
So the explanatory note tells us that the 2013 rules, the regulations, form part of a package of new rules and regulations made under the 2009 Act.
Yes.
And insofar as Note 3 tells us about the standard of proof for narrative statements, that is of necessity something new, because there wasn't any. Or am I right in thinking that that's something new?
It is undoubtedly something new.
Yeah.
Mr. Hoff, when Lord Reed and I look at the explanatory note at the back of 7, are we looking at an explanatory note to different regulations?
You are looking at the explanatory note for the coroner's investigations regulations rather than the coroner's inquests rules.
That's what I thought.
Yes. The investigations regulations concern the conduct of investigations generally, whereas the inquest rules are concerned with inquests. They're very much like court rules.
So we'll wait for Ms Monaghan to produce the relevant note.
But it was helpfully just handed to me, and by way of sneak preview of her submissions, it will contain a similar comment about the rules and regulations being part of a package introduced under the 2009 Act.
Right. Thank you.
Now, I should again stress that both forms have been intended to facilitate the giving of answers to the same prescribed statutory questions, who, when, where and how, and the death registration particulars. May I now return to the standard of proof for suicide and arguments for the criminal standard to apply. I'll spend less time dealing with those because they have been developed so comprehensively and skillfully by Ms Monaghan. Nevertheless, there are some points on which I'd like to elaborate briefly on behalf of the Chief Coroner, stressing once again that his position is non-partisan. And this begins, for those following our case, from page 21 of our case. First of all, the use of the criminal standard of proof for findings of suicide in inquests is supported by a large body of authority. As to the cases which predated ex parte evidence, it can fairly be said that the judges sometimes went further than merely saying that suicidal intent should not be too readily inferred. They sometimes spoke in more emphatic terms. The best example can be seen in Authorities 4 tab 43, authorities 3 tab 43, case of ex parte Barber, which is MS 1501, at MS 1504, page 1313, my lords and my lady have been shown an extract of Lord Widgery's judgment because it was quoted by Lord Justice Watkins in the Gray case, but at 1313E, after the passage which you have been shown, towards the bottom of the paragraph, Lord Widgery says, "There is, as I see it, no single fact which definitely points to the deliberate taking of this man's life, and every possibility that the matter was an accident and no more." And it is fair to say that passages such as that, and other examples have been quoted in our case and the appellant's case, it's because of passages such as that not only Lord Justice Watkins in Evans and Gray, but also Lord Justice Wolfe in Armstrong and Lord Justice Parker in Hopper evidently considered that the early cases supported the criminal standard of proof. As I said yesterday, Lord Justice Wolfe in Armstrong and Lord Justice Parker in Hopper took that view that the early cases supported the criminal standard of proof without making reference to Evans or to Gray. It's also fair to say, by reference to this body of authority, that in the cases that followed, many experienced judges readily accepted that the criminal standard applied to suicide conclusions, although not bound by authority to do so. Lord Justice Wolfe in Armstrong and Kerbin, Lord Justice Bingham and Mr. Justice Leggett in Walker, Lord Justice Lloyd in Nutt, Lady Justice Hallett in Sridharan. Secondly, the judges in all these cases did not all just blindly follow an orthodoxy, or follow an orthodoxy without giving reasons. On a number of occasions, they gave principled reasons for the criminal standard to apply to suicide conclusions. And those were really threefold. First, the serious social, economic, and other consequences of a suicide finding. Secondly, what was described repeatedly as the unnecessary stigma produced by a headline conclusion of suicide in an inquest. And thirdly, the danger of inferring suicidal intent from action and circumstances. My lords and my lady have seen the passages in two of the cases, ex parte Gray at MS 891 and ex parte Kendall at MS 1479 to 80. Those points were also made in perhaps slightly more modern language by Mrs. Justice Lang in Lagos at MS 1736. Suicide, my lords, may be said to be an unusual verdict. As we've submitted, it has a history rooted in a time when suicide was a crime and suicide findings could have immediate and devastating consequences. And it's a headline or label which still has an acute capacity to cause distress. For that reason, both the Wright Committee in 1936, MS 2495, and the Fundamental Review of 2003, MS 2614, recommended that it be replaced with a more neutral phrase saying that death had resulted from the deceased person's own deliberate act. Such a conclusion would, of course, carry no necessary implication about whether the deceased person intended the fatal outcome rather than simply acting deliberately in the physical acts. It may also be argued that as long as our legal system presents coroners and juries with a conclusion involving a finding of suicidal intent, which will often be unnecessary to the wider set of conclusions as to the circumstances of death, that conclusion should be subject to a heightened standard of proof. Thirdly, the statutory reform package comprising the Coroners and Justice Act 2009 and the associated rules and regulations was introduced against the background of this line of authority. The 2009 Act, as we've seen, maintained the basic statutory scheme governing inquest conclusions. As we've also seen, the 2013 rules were made under a power wide enough to stipulate particular standards of proof. On any view, the rulemaker did not seek expressly to modify the existing position. The rules provided for a record of inquest form, required it to be used in all cases, whereas the predecessor rules scheduled an inquest form which might be used, but did not have to be used. The record of inquest form contained for the first time guidance on standards of proof, referring to the criminal standard of proof applying to findings of suicide and unlawful killing. Now, I've addressed in some detail the question of whether the note mandates standards of proof. That's a matter of statutory construction, which I've covered. But in any event, whatever decision is taken upon that, even if it doesn't mandate the standard of proof, it can be fairly said for the appellant's position that a legislative package was introduced against the background of a clearly understood legal position which neither Parliament nor the rulemaker chose to disturb. Fourthly, there are proper grounds for drawing a distinction between inquests and civil proceedings regarding the standard of proof for suicide conclusions. First of all, in civil proceedings, the concern is usually to strike a fair balance between the interests of competing private litigants, often their economic interests. In that context, the balance of probability standard for issues of fact is the fair and logical touchstone of proof. Any other standard would unfairly penalise the party bearing the burden. By contrast, an inquest determination is a finding for the public record. A short-form conclusion of suicide is entered as an indelible label, a headline conclusion, in the person's entry in the Register of Deaths. An inquest is an inquisitorial proceeding conducted by the coroner. There are important limits on the participation of the bereaved. They may not require the calling of a witness and may not make a speech on the facts. At the same time, rules of evidence are very relaxed. A family such as the Maughans might fairly object that an exacting standard of proof ought to be met before the state, through a state official, authoritatively records a death as a suicide based on a process in which the family have limited rights. And fifthly, the approaches taken in other jurisdictions, while far from uniform, show that our courts have not been alone in reflecting concerns about the stigma attaching to suicide findings. Some other jurisdictions have adopted a civil standard of proof, while suggesting that a particularly high level of probability needs to be shown. Those which have adopted the civil standard of proof have usually done it in combination with the sliding scale theory. A few jurisdictions have adopted the criminal standard, namely Hong Kong, Ireland, and until recently Northern Ireland. The appellant's case deals with these with the comparative jurisprudence at paragraph 61 to 64, and our case at paragraph 52. So, my lords, my lady, those are what I propose to say about the standard of proof for suicide findings. Before moving on to unlawful killing, I would respectfully make 2 points by way of coda. First of all, the coroner who conducted this inquest gave directions which were perfectly in keeping with the bench book and chief coroner's guidance. He cannot be fairly subject to any personal criticism, and I don't think anybody does. The bench book and guidance reflected the state of the law as it was generally understood at the time. They will, of course, be revised after the decision of this court. Secondly, I don't propose to develop now any argument for the criminal standard of proof to apply to short-form conclusions of suicide, while the civil standard is applied to equivalent findings in narrative conclusions. There is an argument for that. It's set out briefly at paragraph 54 of our case, but we recognise the force of the arguments against having different standards of proof for the same factual findings depending on how they're expressed. May I now turn to unlawful killing, unless my lords and my lady have anything more to take up with me concerning suicide.
There's just one question. The government has had the opportunity, and indeed, as I understand it from your case, has taken the opportunity to discuss whether or not to amend the rules. Is that right?
The Chief Coroner's guidance refers in a footnote to the fact that the Ministry of Justice had been considering standards of proof. a decision was evidently made not to mandate them subject to what is thought about the meaning of the rule, of the footnote.
Yeah. But not to mandate them, but not to change the note.
Absolutely.
So there's a conscious decision on the part of government not to change the note.
Anyone producing the Coroners and Justice Act 2009 and the rules and regulations could be expected to have known the very consistent approach of the courts to standards of proof.
Yes, but also the note.
Yes.
In the, what significance should be attached to the apparent decision of government not to do anything about it?
Well, there are three kinds of significance that might be attached. The first, most extreme form, is to say that the note was mandating standards of proof. That depends on a question of statutory construction I addressed. The second is a more nuanced way of looking at it, which is that the courts adopted an approach to standards of proof which the legislature chose not to interfere with.
And in fact has explicitly recognised in legislation.
Yes, even if not mandating,
Yeah.
recognised.
Yes, even if they're not prescribing it,
Absolutely.
they've recognised that that was the state of the law.
And at the other end of the spectrum is simply to say that Parliament chose not to grapple with this difficult issue while describing the existing legal position and leaving it to the courts to develop the law as they saw fit.
But the development of the law by the courts has to be taken against the background
Absolutely.
of the note. I mean, on one view, it would be a remarkable thing for Parliament to have expected the courts to depart from the explicit language of the rules.
Well,
on one view.
yes.
The other view, perhaps not.
Yes. I've set out.
To articulate the other view somehow, but at the moment, as my Lord would put it, it seems to me, that it is in these days when there's a lot of discussion about the synergy between Parliament and the courts, that where there is an express statement, putting it no higher than that, in the rules, and government has the opportunity, and apparently has taken the opportunity, but decided to do nothing, that it would be appropriate for the courts to act in, well, not if not in defiance, certainly in a way which is not in accord with the statement in the rules.
Yeah.
Well, certainly that is an argument. On the other hand, as we've explored over the course of this case, there have been a number of intersecting judicial trends. So at the time that some of these decisions about standard of proof in inquest were being made, there were different views of the courts towards standards of proof more generally. Moreover, what this case has really shown up is that short-form conclusions and narrative conclusions can interact in ways which pose particular difficulties, which appear not to have been focused upon in the cases leading up to the 2013 reforms.
Yeah, thank you.
May I turn then to unlawful killing, which is addressed from page 25 of our case.
It occurs to me, just before you embark on it, that the support for what Lord Kerr has been putting to you in the decision of this court in a case called Prudential Assurance about 2013, which concerned legal professional privilege.
Yes.
And the question was, should it be extended to non-lawyers, for example, accountants, when they're giving legal advice? And the court answered the question in the negative, on the footing that the government and Parliament had reviewed this area of the law and had decided to do nothing. And in those circumstances, it was felt the court shouldn't step in, despite the fact that there was no legislation to stop them I mean, the position was weaker in some ways than in this case. There was nothing in legislation to stop development of the common law, but it was felt that such development was inappropriate where the government and Parliament had considered that field and had decided not to legislate.
I may be misremembering, but as I recall, that case also founded that decision on a fair amount of analysis of principle and also some consideration of comparative. Position.
Yeah. There wasn't.
Yes, I think we need to look at that if we're going to draw any conclusions, because I don't remember it being entirely straightforward.
Yeah,
I mean, what is the evidence that Parliament has considered this issue? All we have is a footnote.
Yeah.
Isn't it?
Well, I'm not. I recall following the reform procedure, and I'm not going to give evidence, save to say that I don't recall anything being said in any of the committee sessions about standards of proof. Determinations weren't considered in great detail. My lords may remember that at the time of the 2009 Act, the hot button issue was secret inquests. That was what Parliament was particularly concerned with. And when the 2013 rules and regulations came in, there was very little consideration at a parliamentary level about their precise provisions.
There was some incorporation of the recommendations of the Law Commission, wasn't there, from the murder report?
Yes. Well, it was the 2009 Act, of course, was an omnibus bill covering a lot of subjects. May I then turn to unlawful killing? This wasn't addressed in any detail in the Divisional Court, and the Court of Appeal rightly held that it was bound by the decision in McKirbin to say that the criminal standard applied to the unlawful killing conclusion. Lord Justice Davis, with admirable fairness, set out the arguments for and against paragraphs 91 and 93 of his judgment. Through its intervention, Inquest seeks to make the case for the civil standard of proof to apply to unlawful killing, at least if that standard is applied to suicide. The Chief Coroner's particular concern is that the court should be aware of arguments in favour of the criminal standard continuing to apply to unlawful killing, that being a particularly significant conclusion which arises in many controversial cases. We make 7 points in this regard in our case, which I'd like to develop. The first is that the unlawful killing conclusion is unique among inquest conclusions in a number of important respects. It's a conclusion that one of 3 specific homicide offences has been committed in relation to a death. We saw that from the note to the 1984 rules. That is to say that all the elements of the offence could be proved against a defendant and that there is no lawful excuse. So it's not just a finding of fact about the means or circumstances of the death, it is a finding of a criminal offence. Furthermore, it often encompasses value judgments based on rules of the criminal law. In a case of unlawful killing based on gross negligence manslaughter, has the breach of duty been gross? In a case of unlawful killing with a possible defence of self-defence, has the use of force been reasonable in response to the honestly perceived threat? In all other respects, the purpose of an inquest is to establish the facts of a death without even appearing to determine any form of legal liability. The unlawful killing conclusion uniquely does make a finding of legal liability, although without naming the perpetrator. The conclusion, as we saw, survives from a time when inquests performed the function of a grand jury. While that function has been removed, the unlawful killing conclusion remains a criminal law concept. Secondly, and relatedly, the conclusion is governed by rules and principles which are peculiar to the criminal law. And a clear example comes from the recent case of Duggan, where the courts held that the criminal law of self-defence applies when considering whether or not deliberate use of lethal force is lawful. May we go briefly to that case, which is at Authorities Bundle 4, Tab 50, MS 1633. Authorities 4, tab 50, MS 1633. This concerned the well-known fatal shooting of Mark Duggan by police firearms officers in London. A verdict of lawful killing was challenged unsuccessfully. The second limb of the appeal was an argument that the coroner should have directed the jury to reach a conclusion on whether the officers had acted in lawful self-defence by applying civil law rather than criminal law concepts. And we see that argument addressed from MS 1651, page 2217 internally, paragraph 88. And we see from paragraph 88 that the argument was whether the coroner should have directed the jury to reach a conclusion on whether there had been a lawful or unlawful death for the purposes of the civil law. And then over the page at 1652, the Master of the Rolls, along with the other members of the court giving a judgment of the court, said, paragraph 91, there are several differences between the criminal law and the civil law on self-defence. He identifies what those are, including the different standards of proof. Moreover, and importantly, there's a difference as to the relevance of reasonableness to the issue of the defendant's honest and genuine belief of imminent danger. In the criminal law, the question is honest belief; in the civil law, reasonable belief. That distinction is then elaborated by reference to the Ashley case. At paragraph 93, the court says this: "We were not shown any domestic case which requires an inquiry as to breach of civil law at an inquest. Judgment of the Divisional Court gave a succinct and lucid historical account of the form of verdicts at an inquest of justifiable or excusable homicide and the modern conclusions of lawful and unlawful killing. As that account shows, it has never been the function of an inquest to concern itself with civil liability for a death, and the conclusion of lawful killing has always been understood to have been linked to crime and amounted to a statement that the jury believed that the deceased was probably not the victim of a homicide." So conclusions of unlawful killing have always been linked to crime, in the phrase of the court.
So where does that take one on burden of proof?
Well, where that takes one at the first stage is that the conclusion of unlawful killing is governed by rules and principles of the criminal law. It is a concept of criminal law. And there would be an oddity in having a procedure that found that a peculiarly criminal law concept, peculiarly criminal law offence, had been committed by applying a civil standard of proof. And my Lord saw all those cases yesterday where judges said, well, this is a civil proceeding, so it should have the civil standard of proof. Well, the converse point can surely be made here. Thirdly, although an unlawful killing conclusion cannot and will not name the offender, it will usually be obvious from the evidence and from the coroner's summing up and directions who has been found to have committed the offence. The person will often be named in press reports as the guilty party. Indeed, a coroner giving directions to a jury will often tell them that they have to identify a guilty person without naming that person in their determination. That may be necessary, for example, to avoid improper aggregation of the errors of several different people in cases of gross negligence manslaughter. It may also be necessary in order to give proper legal directions about joint enterprise.
So how are they expected to identify without naming?
Well, they may be told, you have to decide that one particular person did all the acts necessary for a criminal offence, but you will not name that person. So
then he's not identified.
No, the jury identify him or her in their own minds. Yes, they don't identify them.
I misunderstood you. I thought you said that the coroner directed the jury to identify without naming.
No. The coroner may say, you can only reach this conclusion if you decide that Mr. X did A, B, and C. And so it will be not just apparent from a review of the evidence, but from the most cursory review of the coroner's directions, who the person is. And it would be a perfectly legitimate press report to say that the jury's conclusion means that they have found that Mr. X committed this criminal offence. And for this reason, for example, Mr. Justice Leveson in the Sharman case said that the significance of an unlawful killing verdict cannot be overemphasised, affecting those directly involved and the wider public. For your note, MS 1929, paragraph 50. In the case of Anderson, Mr. Justice Collins said that this feature alone justified the application of the criminal standard of proof to unlawful killing. For your note, MS 1598, paragraph 21. And Mr. Justice Leveson agreed with that in Sharman, MS 1917, paragraph 10. Fourthly, an unlawful killing conclusion acts as an immediate and direct spur to a potential prosecution. There is a standing agreement between the CPS and various other parties, including the Chief Coroner, which commits the CPS to considering the possibility of a prosecution. For your note, MS 306, clause 6.1. That accords with suggestions which the Broderick Committee made when they first recommended that inquest verdicts should not act as bills of indictment. Now, the courts have arguably gone further than the agreement goes by saying that a prosecution is usually expected following an unlawful killing verdict. And we see that from the case of Manning, ex parte Manning, which is at Authorities 3, divided 32, MS 1348. 1348.
Is that referred to in your case? Or?
It is. Now, the relevant part of that judgment is paragraph 33, MS 1365, where Lord Bingham is addressing the obligations of a director to give reasons for decisions not to prosecute. And in that context, he considers the relevance of an inquest with an unlawful killing determination. Just below letter D, Lord Bingham says the holding of an inquest in public by an independent judicial official, the coroner, in which interested persons are able to participate, must, in our view, be regarded as a full and effective inquiry. Where such an inquest following a proper direction to the jury culminates in a lawful verdict of unlawful killing, implicating a person who, although not named in the verdict, is clearly identified, who is living and whose whereabouts are known, the ordinary expectation would naturally be that a prosecution would follow. In the absence of compelling grounds for not giving reasons, we'd expect the director to give reasons in such a case. That would meet the reasonable expectation of interested parties. So that's what the courts require of the director. Fifthly, while the statutory materials don't address standards of proof directly, they do contain some indications, again that's subject to the note, they do contain some indications that the criminal standard applies to unlawful killing. We saw yesterday section 10.2 of the 2009 Act, which precludes an inquest conclusion appearing to determine any question of criminal liability on the part of a named person. That form of words implicitly preserves the unlawful killing verdict, as we saw from the Jameson judgment. But by the same token, it implicitly presumes that the verdict would either determine criminal liability or at least appear to do so. And it would be odd to regard criminal liability as being determined or apparently determined other than by reference to criminal standards. The other clue is in Schedule 1 to the 2009 Act, which makes provision for inquests to be adjourned pending criminal prosecutions and sometimes resumed afterwards. We see the relevant part of that schedule at the very last divider of Authorities 7, divider 114, MS 2679, paragraph 8 of Schedule 1, headed Resumption of Investigation Suspended under paragraph 2. And at MS 2680, sub-paragraph 5, states that in the case of an investigation resumed under this paragraph, so an investigation resumed after a prosecution, a determination under section 10(1)A may not be inconsistent with the outcome of the proceedings in respect of the charge, or each charge in respect of which the investigation was suspended. Now that too suggests, we say, a recognition that the inquest may address the same issue of criminal liability, and one would expect that to be in accordance with the same tests. I don't say that either of these indications is definitive, but that each of them suggests that there is a coherence between the approach of the criminal and coronial courts to determinations of criminal liability. Sixthly, retaining the criminal standard for unlawful killing would not give rise to the same problems of practice, logic and fairness, which at least arguably arise if that standard is applied to suicide, and that's because the unlawful killing conclusion is not just a finding of fact. As I said yesterday, in the case of suicide, it may be necessary to make factual findings about whether a person intended his or her own death for the purpose of answering the factual question of how he or she died. And as I submitted, it may be illogical to set a particularly high bar for a factual finding of suicidal intent. Doing so may unfairly influence conclusions on interdependent factual issues. But by contrast, answering the factual question of how a person died doesn't require one to say that a homicide offence was committed. The two issues can be addressed quite separately. Take the case of a car accident. The coroner can ask the jury to determine the facts of how the accident happened on the civil standard, and then may ask them to consider separately on the criminal standard whether the offence of gross negligence manslaughter was committed. And in that regard, it's telling that conclusions of unlawful killing aren't permitted either in inquests in Northern Ireland or in fatal accident inquiries in Scotland. In both those jurisdictions, factual findings may be made that may point towards civil or criminal liability, but each has a regime precluding any finding of unlawful killing. We put in sections 1 and 26 of the Fatal Accidents and Sudden Deaths, Inquiries into Fatal Accidents and Sudden Deaths Scotland Act, into the slim file that my lords and my lady received yesterday morning. That is because we see from section 1.3 of the 2016 Scottish Act that the purpose of a fatal accident inquiry is to establish the circumstances of the death, similar to an inquest. But 1.4, it is not the purpose of an inquiry to establish civil or criminal liability. The position in Northern Ireland is addressed in some detail in the case of Jordan and the Lord Chancellor, which Lord Kerr may have some familiarity with, which appears in the...
Wasn't in a judicial capacity?
Yes. Which my
That's not true. I did have some familiarity with it in a judicial capacity. Yes, I'm sorry. Don't be distracted.
Authorities 328, MS 1321, paragraphs 38 to 39 for your note. So that's the position in those two jurisdictions, and it shows that it's perfectly possible to have a death investigation system which makes full findings about circumstances of deaths. In fatal accident inquiries in Scotland, one sees lengthy reports giving great detail about the circumstances of death and what might be done to prevent similar deaths, but no finding of criminal or civil liability. Seventhly, setting the civil standard of proof for findings of criminal homicide in inquests only increases the prospect of there being more unlawful killing verdicts, which are either not followed by prosecutions or are followed by unsuccessful prosecutions. Those involved in inquests and the wider public can understandably find it difficult to accept when there is an unlawful killing verdict at an inquest and then a prosecution brought on the same basis fails. That, of course, happened notably in the recent Hillsborough case. And this isn't just a matter of presentation, it's also a matter of principle. It can be said to create incoherence in the law if the standard for determining a criminal offence, the finding of a criminal offence for the public record, differ between different parts of the legal system. Now, that prospect of different conclusions would be increased by the setting of different standards in the different parts of the system.
But you have that anyway, don't you? You have a situation where this criminal prosecution may result in acquittal, but those affected may want to bring a civil proceedings to try and establish on the civil standard that it was a result of an intentional killing.
There can be an inconsistency there, but there is a greater inconsistency here, because in an inquest, a public official is finding the commission of a criminal offence for the public record, just as a jury does in a criminal trial. In the civil case, there may be common factual issues which arise, but the High Court judge will not make an explicit finding of a criminal offence. He will make findings of fact necessary to determine the list before him or her. And that is of significance because it does involve different parts of the legal system finding a criminal offence for the public record by its fundamentally different standards. And that can be said to introduce incoherence. May I finally answer the main arguments made by Inquest in its printed case?
Sorry, before you do, can I just, I'm just thinking about the fifth point you made, which was to do with Schedule 1, paragraph 8(5) to the 2009 Act. And it tells us that effectively where the inquest has been suspended, or the investigation, to use the proper terminology, where it's been suspended to enable criminal proceedings to take place, we're told that in the case of an investigation resumed after the criminal proceedings have come to an end, a determination under Section 10(1)(a), in other words, the determination by the coroner or by the jury, may not be inconsistent with the outcome of the criminal proceedings.
Yes.
I'm just wondering about wondering if that really is a pointer one way or the other. I mean, thinking about inconsistency, it can't be formally inconsistent because we know that the determination can't identify anybody. So you're not going to have a situation where Mr. X was acquitted and a jury say unlawful killing by Mr. X. That's ruled out anyway. So I suppose it must be meaning, well, the basis of the determination would be inconsistent. But if the only basis for a finding of unlawful killing would be unlawful killing by Mr. X, yes, that must be ruled out by this because it would be inconsistent with his earlier acquittal. But does that tell us anything about whether the standard of proof is civil or criminal in the inquest?
All we say in that regard, and as I say, it's not a determinative point. The reason it may be an indication is that Parliament here appears to be assuming that equivalent determinations are being made in the two processes, which suggests at least a common approach to the factual prerequisites of the offence. I don't take it any further than that. It is no more than a clue or indication.
Thank you.
Could you just paragraph 55 of your case you say that the strong arguments against having different standards for the same factual findings depending whether they're short form or narrative. And that, of course, is a reference to the rather curious wording of the note. How does this work in an unlawful killing situation? I mean, assume you're right that unlawful killing ought in principle to be the higher standard. How do you reconcile that with what's said about narrative conclusions in the note?
Well, because there is no difficulty in saying to a civil standard of proof that somebody was shot by police officers, or was stabbed to death, or was run over by a car. The finding of a criminal offence is a different sort of finding.
Well, I understand that, but the note doesn't seem to distinguish on that basis. That's what I find difficult.
Yes.
I mean, the note seems to distinguish on whether it's short form or narrative, which seems a very illogical distinction to draw.
We would agree, and my Lord has our submission in that.
Okay, well, that's... No, I just want to be clear. I mean, if the Chief Coroner is clearly in a sort of delicate position, trying to avoid being pushed too far, I'll ask you when you've dealt with it towards the end where we actually got to, but you're now turning to the inquest submission.
I was going to deal with the submissions of inquest unless I can assist on anything before that.
Well, I'm trying to get a feel for where the Chief Coroner stands. I mean, the impression I get is you're pushing us in the direction of saying unlawful killing requires the criminal standard. And we're going to deal with the inquest arguments on that. But the impression I have that on the suicide thing, you seem to be actually moving in the direction of saying, well, that can be a civil standard. Well, and now is that an unfair characterisation?
Well, I think the latter part I would cavil at, because the Chief Coroner has been and remains in this court scrupulously on the fence.
What I am getting is it wouldn't worry the Chief Coroner who had different standards for suicide and unlawful killing.
The Chief Coroner does not consider that would create a difficulty in practice, nor that it would create a principal problem. Of course, the court could adopt, and the Chief Coroner isn't trying to guide the court in any particular direction. The court could adopt the civil standard for the elements of unlawful killing. What the Chief Coroner is concerned that the court should appreciate is that there are a series of cogent arguments why the two don't necessarily go together.
But I just wanted to make sure I understood where we've ended up, and I think I now understand.
Can I ask you this? I can see quite easily how, applying the footnote, you could have a determination that someone committed suicide arrived at on a criminal standard, but then have a narrative on a civil standard basis, illustrating perhaps shortcomings in monitoring by prison staff and the like. Factors which don't actually affect the conclusion that the man committed suicide, but which would go to whether appropriate steps had been taken to guard against that risk.
Yes.
In a situation of unlawful killing, if one reads the note as implying that a determination of unlawful killing has to be in the short form conclusion on a criminal standard, what sort of things could go into a narrative?
Well, all sorts of things could go into a narrative. To take the case of the person who is killed by their cellmate, because, and these are the facts of the Maughan case, because the prison authorities failed to recognise that the cellmate was a racist and shouldn't have been a violent racist and shouldn't have been put in the same cell as somebody of an ethnic minority.
Yes, so I think it's really, the example you're giving is analogous to the suicide example. You're talking about how a third party's failure to take reasonable care in tort terms might go into a narrative.
But also, and to take some of the police shooting cases as an example, the narrative, the short form, might consider whether the police firearms officers acted in lawful self-defence, but the narrative might consider the planning of the police operation, which might not itself give rise to a potential finding of gross negligence manslaughter, but might nevertheless justify findings that the authorities planned the operation well or badly.
Yes, I see. And for example, there could, I suppose, be issues about, well, I mean, we're assuming that there's a verdict of unlawful killing, so I suppose it might be accompanied by a narrative describing perhaps shortcomings in the training of firearms officers.
Yes. Yes.
Or in the selection of them.
Yes. But the difference between the interaction of short form and narrative between suicide and unlawful killing is that for suicide, a coroner attempting to direct himself or the jury to follow a sort of route to verdict may pose the question about suicidal intent along the way. And there is at least an oddity about then taking that finding out of the narrative which deals with the interdependent findings. Whereas with the unlawful killing determination, because unlawful killing is a finding of law, one can always have the findings of fact fully explored and dealt with on the civil standard, but then address the determination of law on the criminal standard.
Is there a difficulty about having a route to verdict series of questions leading to a short form conclusion?
No, because it is usually possible, it will always be possible to provide that set of questions with clear directions on the criminal standard of proof, but then have separately the findings of fact for the purposes of for the purposes of a narrative conclusion.
Yes, just as in a criminal trial, you could have a series of questions which lead to what's effectively a short form conclusion.
Yes, and coroners adopt routes to verdict just as Crown Court judges do. Yeah. Addressing then the arguments of inquest, the first argument repeatedly made is that the civil standard of proof is justified for the unlawful killing conclusion because of the potentially adverse consequences of, quotes, getting the conclusion wrong. See, for instance, paragraphs 16 and 40 of Inquest's case. What we would say to this is that if a coroner or jury finds that the evidence doesn't establish a homicide offence to the criminal standard of proof, they're not getting their conclusion wrong. Determining whether or not death was due to a criminal offence is never essential to answering the question how a person died. If it were, inquests in Northern Ireland and fatal accident inquiries in Scotland would be inadequate for their purposes. If it were, then the fundamental review would not have recommended, as it did, abolishing the unlawful killing conclusion while retaining detailed narrative conclusions. That's MS 2598, paragraph 37. Secondly, Inquest submits that applying the criminal standard of proof to the verdict of unlawful killing can inhibit an inquest from serving its proper functions of bringing the full facts to light, exposing discreditable conduct, and identifying dangerous practices. That's paragraph 25 of Inquest's case. And to that submission, we'd say something similar to that which we said about getting the conclusion wrong. A coroner or jury who conclude that the evidence doesn't establish a homicide offence to the criminal standard of proof aren't thereby prevented from making any factual findings about the cause and circumstances of death. In appropriate cases, those findings may be critical or otherwise judgmental. In particular, in cases where the Middleton approach applies, they can identify errors of individuals and failures of systems. An Inquest itself submits at paragraph 31 of its case that it is meaningful narrative conclusions which really provide the detailed answers that bereaved families need. It is not the availability of the unlawful killing conclusion that means inquests can or can't serve their proper functions. After all, in most cases, that conclusion is not even in play. And once again, we'd refer to the position in Northern Ireland and Scotland, where inquests and inquiries are no less effective for lacking the unlawful killing conclusion. Thirdly, Inquest suggests that there will be some cases where applying the criminal standard of proof for unlawful killing creates confusion. And at paragraph 28 of its case, it gives an example of a case where a person has been shot and there is an issue whether the shot was self-inflicted or fired by another person. What inquest says is that if there's a higher standard of proof for unlawful killing than for suicide, and the jury returned an open conclusion in those circumstances, confusion would reign. Inquest says that it would be unclear whether the jury thought this was probably murder or probably a self-inflicted wound with suicidal intent unclear. Although the example has been neatly thought up, the answer to submissions of this kind is simple. It sometimes happens that a choice between short-form verdicts can produce a confusing or unclear outcome. That can happen whatever view is taken about standards of proof for particular conclusions. When that happens, the coroner should provide, or if sitting with the jury elicit from them, a short supplemental narrative to avoid such confusion. Take, for example, the inquest concerning the death of Princess Diana. It was open for the jury to find that she was unlawfully killed by grossly negligent driving of the car in which she was a passenger. It was also open for them to find that she was unlawfully killed by the grossly negligent driving of paparazzi on motorcycles following her. A simple conclusion of unlawful killing would have left matters confused. What Lord Justice Scott Baker did was to produce a questionnaire for the jury which allowed them to specify, and they did specify. They held it was both. Fourthly, inquest argued that there are a number of safeguards in inquests to ensure fairness to somebody whose conduct is in issue, including a right to disclosure, a right to examine witnesses, and a privilege against self-incrimination, paragraphs 32 to 35 of its case. And we entirely agree that those safeguards exist. But the fact remains that a person whose conduct is under scrutiny does not have rights of participation nearly as extensive as those of a party to civil or criminal proceedings. Furthermore, and importantly, inquests will very often receive evidence that would be inadmissible in a criminal trial, increasing the propensity for unfairness if criminal liability is found against an identifiable individual on the lower standard of proof. Fifthly, inquest submits that inquests reach other findings indicating that criminal offences have been committed, paragraph 44 of its case. And we can readily accept that in some cases a narrative conclusion of the facts of a death may indicate or imply that some criminal act has been committed. That's the case too in Scotland and Northern Ireland. But there's an important distinction of principle to be drawn between findings of fact and the unlawful killing conclusion. The latter is unique in being a legal conclusion for the public record that a criminal offence, specifically a homicide offence, has been committed. Sixthly, inquest submits that the prospect of an unlawful killing conclusion leading to a prosecution shouldn't result in it being treated differently. And we fully accept that the conclusion doesn't automatically lead to a prosecution, and that other conclusions can sometimes lead to prosecutions. But both the CPS agreement and the ex parte Manning judgment make clear that unlawful killing conclusions at inquest have a particular significance. At paragraph 53 of its case, inquest makes the argument that the test applied by the CPS in deciding whether or not to prosecute is, quotes, closer to the civil standard. A conviction is more likely than not. That argument is, we suggest, misconceived. The evidential stage of the full code test asks whether a jury would probably find the offence proven to the requisite standard of proof, the criminal standard of proof. The CPS test expressly builds in the criminal standard, as can be seen from the test, paragraph 4.7, MS 2322 to 2323. Inquest also observes that Rule 25 of the Coroner's Inquest Rules requires a coroner to adjourn an inquest and refer the case to the DPP if on the evidence that is coming out in the inquest, it is likely that death was due to a homicide offence and a person may be charged. And what inquest says is, if probability is enough for adjourning an inquest on this ground, why not also for a substantive conclusion of unlawful killing? That's paragraphs 50 to 52 of inquest's case. The answer, in short, is that Rule 25 serves an entirely different purpose. Its purpose is to prevent the prosecution taking place after the inquest, with the potential prejudice that may cause. And we can see that from the fact that it's a test with two limbs involving the possibility that a person may be charged. Seventhly, Inquest argues that reducing the standard of proof for unlawful killing would improve clarity and consistency, paragraphs 56 to 58 of its case. It argues first that directing juries is more complicated when one conclusion has a higher standard of proof. With respect, whatever one might be said about the judgment of the Court of Appeal in McKirbin, what it did do was give clear guidance on the proper means of directing a jury, the order in which to consider conclusions. Coroners have been applying that for decades without apparent difficulties. Inquest also argues that the unlawful killing conclusion may be, quotes, very similar to or interrelated with other conclusions. And in particular, it suggests that unlawful killing by gross negligence manslaughter is very similar to the adjectival conclusion of neglect, which was considered in the Jameson case. Now, I don't propose to go into the very considerable case law on neglect, but I'd simply say this: neglect is a term of art which the courts have repeatedly stressed is different from common law negligence. See the Jameson case, page 25A to B, MS 1529. Inquest also suggests that narrative conclusions which may make critical findings, for example about missed opportunities to save life, can raise issues similar to those raised by considering the unlawful killing conclusion. But there is a critical distinction, as I've suggested. The narrative findings will be factual conclusions, whereas the unlawful killing conclusion uniquely is a determination of law, and a dramatic one at that. I said at the outset of my submissions that I would repeatedly stress that in most respects, Parliament and the courts stress that inquests are there to determine matters of fact, conclusions of fact, judgmental conclusions of fact, and so on. The unlawful killing conclusion, because of its peculiar history, is different. And therefore it can, for all the reasons I've suggested, justify a different approach, whatever my lords and my lady decide concerning suicide. Of course, inquest raises a number of points.
Mr. Huff, you're now about a quarter of an hour beyond your time, so you'll need to draw your remarks to a close very soon.
I have now finished.
Good.
And I had agreed to take 15 minutes of Ms. Hewitt's time, so I hope I have not created...
I think you may have taken rather more than that, if she's to speak at all.
I'm sorry. I hope that the submissions have been of assistance. Thank you, my lords, my lady.
Yes. Ms. Hewitt, I'm afraid your time has also been swallowed up by Mr. Hoff. Is there anything you feel you need to add?
No, is the short answer. Say that I was going to ask for 5 minutes, really just to reiterate matters from the respondent's point of view.
Well, we don't need anything reiterated.
May I bring it even perhaps down just a few minutes?
Yes.
Because I recognise, or it's been said already by Ms. Monaghan, that the respondent takes a neutral stance, and of course that's right. I recognise that there has been no criticism made of the approach he took. I'm grateful for the indication by Mr. Hoff a moment ago. All I was going to do was to reiterate from his point of view that precisely what he did was in accordance with the law as it was then understood to be, precisely in accordance with the guidance. And perhaps to emphasise this...
Yeah, I just ask, the guidance has no particular significance, does it? Or does it? I mean, there's so many forms of soft law nowadays.
It's guidance.
But it's simply guidance.
It's guidance. The guidance and the coroner bench book was what were followed, but yes, they don't have a force of law. No. That's correct.
And the guidance is produced by the Chief Coroner, not by the Home Office.
That's correct. Yes. And I think the coroner bench book by the first Chief Coroner. I think the point that in particular the respondent asked me to make is that in following that guidance, he was not doing so blindly and unthinkingly, but he thought that he was driven to what he did do because of the clash, if I can put it that way, between following through the standard of proof for suicide in the short form, but then having to comply also with the investigatory duty under Article 2.
Yes.
And he thought there was good reason for seeking the jury's findings of fact on the elements of suicide albeit on the balance of probabilities, in order to be the foundation for their proper findings for Article 2. And he took the view that although he recognised what is thought to be unacceptable by the appellants, that what appeared on the record of inquest was not the word suicide. And although the elements of suicide were there and found, they were expressly said to have been found on the balance of probabilities. And so maybe a rather legalistic approach to that extent. That is why below he took the view that is that a contravention of the direction that suicide should only be found beyond reasonable doubt? Well, that's a matter for the court to say. But on the face of it, he didn't think it immediately was a breach for those reasons. And it's that problem that led him there. He says nothing and adds nothing to Mr. Hoff's submissions on what the outcome should be, save perhaps to make a plea for whatever the outcome is, that when dealing with just this sort of situation, it should be such that relatively straightforward and sensible directions can be given to a jury in order to elicit what is needed for Article 2 in particular. Yes. There's only one other point that, having listened to the submissions, we're going to mention. It's the question of stigma. And again, as with Miss Monaghan, it wouldn't be at all for me or indeed the respondent to give any sort of evidence.
No, or for us.
The only point that would be made is that in the most recent guidance on conclusions, which your lordships and ladyship have, 17, the point is made that if evidence does show that the death was a suicide, then it is suicide that should be recorded. In other words, there shouldn't be a resiling from it because of the sensitivities that that may have for the family. And the respondent's understanding of what lies behind that is the importance of the recording of incidents, the incidents of suicide, not least for public health and understanding of whether there are trends in suicide or perhaps, for example, amongst young people. And if there are, there is an importance in there not being an under-recording of suicide for fear of how upsetting that may be for those involved. So he would add that just by way of comment. But unless there's anything else I can assist with.
No, thank you very much, Miss Hewitt. Mr. Straw.
My lords, my lady. Inquest is neutral on the two issues which are directly on appeal, but submits that there's no justification in principle following recent authority for there being a higher standard of proof for unlawful killing than for suicide. The principles which govern the standard of proof in legal proceedings have been recently clarified in a line of authority which began with Re H and were perhaps most clearly expressed in Re B. The passages that we rely on are set out at paragraphs 4 to 15 of our written case, and in summary are as follows. The general principle in non-criminal proceedings is that where the matters in issue are facts, the balance of probabilities applies. Exceptions are made to that general principle, and the factors which are taken into account in deciding whether to make an exception include matters such as the purposes of the proceedings, their nature, and the need for clarity and consistency. That new line of authority made quite clear that any previous suggestions that there's a sliding scale whereby a higher standard of proof applies for more serious allegations have been abandoned. They also make clear that in non-criminal proceedings, where a criminal offence is at issue, so where a determination is being made to the effect that a criminal offence was committed, that's ordinarily not sufficient to raise the standard of proof. And that's significant in this case because the main reason really given for drawing a distinction between the standard for suicide and that for unlawful killing is that unlawful killing connotes a crime. Whereas those authorities demonstrate that that's insufficient. The consequences of the conclusion may very exceptionally be relevant, in particular when the proceedings are penal or when someone's liberty is at stake. However, it's important to take into account not just the consequences for the suspect, but for others who have a legitimate interest. And in Re B, Lady Hale at paragraph 69 explained that one of the key reasons why the civil standard applies in care proceedings is because they're there to protect the child, and the consequences for the child are equally serious in getting the decision wrong either way. Before this case, those principles have never been applied in a coronial case to decide what the standard of proof should be. How do they apply then in the coronial context? Firstly, an inquest is a non-criminal proceeding, and so the general principle is that the balance of probabilities is appropriate. The purposes of the inquest, in my submission, are better met if the standard of proof for unlawful killing is the civil standard. The primary purpose of the inquest is to ascertain and determine how the deceased died. That may extend to the question as to whether the deceased was unlawfully killed. The importance of determining how the deceased died, and where relevant, whether they were unlawfully killed, is underlined by Article 2, where it is engaged. We agree that Article 2 doesn't require any particular standard of proof for unlawful killing, but it's relevant to the point as to whether the purposes of the inquest favour the civil standard. In Amin, Lord Bingham set out at paragraph 31, which for your note is at MS 1576, Authorities 4, tab 47.
Well, we've got that good quote from you at paragraph 23.
Thank you. It's also quoted by the appellant. And he sets out there the purposes of the Article 2 investigation. And they include, so far as possible, to ensure that culpable conduct is brought to the public notice. And so that really underlines the importance of accurately determining whether or not a killing was unlawful. The higher standard of proof will undermine its ability to accurately determine whether the killing was unlawful for two reasons. Firstly, if the standard is weighted against an unlawful killing conclusion, so that the exacting criminal standard is required before it can be returned, then it's more likely that the inquest will overlook unlawful killing cases. The second reason is there's interdependence between the unlawful killing conclusion and other conclusions that the inquest will need to reach. The divisional court concluded that in order to determine on the balance of probabilities the causal relevance of acts and omissions by state agents to a death, it may be necessary to determine on the balance of probabilities whether the deceased intended to take his life. The same applies to unlawful killing. Take an example where the deceased is found hanging in his cell, and the primary question is whether he was killed by his cellmate or by himself. In order to determine on the balance of probabilities whether failures by prison staff in allowing the two to share a cell were causally related to the death, it may be necessary for the jury to decide whether, on the balance of probabilities, the deceased was killed by his cellmate. A secondary purpose of the inquest, an important one, is the learning of lessons, and we submit that a higher standard of proof for unlawful killing may undermine that purpose. For example, the Harold Shipman case indicates that if unlawful killings aren't identified, then it may be more likely that they recur. As to the nature of the inquest, they're partly inquisitorial. They have relaxed rules of evidence. In the case of Re-U, one of the reasons why the civil standard was appropriate in care proceedings was exactly that they are inquisitorial and have relaxed rules of evidence. And that passage was relied on by the majority in Re B. In addition, it's right that someone who is suspected of an unlawful killing, who I'll call the suspect for shorthand, has less rights to participate in an inquest than the defendant would do at a criminal trial. And it's said that it may be unfair to prejudice someone with a finding of unlawful killing when they have that more limited right to participate. And in order to compensate for that, it's necessary to raise the standard of proof. There are two difficulties with that argument. Firstly, any unfairness is already compensated for to some extent by other factors in the inquest process. So, for example, the coroner's duty, the coroner has a duty to fully, fairly and fearlessly inquire. In addition, there's the prohibition on any determination of criminal liability on the part of a named person. It's also necessary to take into account the rights of the family and the public. They too may be prejudiced by an outcome in an inquest. Take, for example, a case where the deceased was shot dead, and the justification put forward by the shooter for it is that the deceased was pointing a gun. A finding that the death was not unlawful may connote acceptance of that justification. It may connote a serious stigma for the family of the deceased. Similarly, for the public, they may be prejudiced by an outcome. They may be at greater risk of future deaths by a finding that a killing was not unlawful. And yet the family and the public face the same limitations on their right to participate as an inquest as does the suspect. And there's no reason why one should take precedence over the other in my submission. Moving on to clarity and consistency. Inquests say that clarity and consistency are better served by having the civil standard applied across the board. That is, clarity and consistency would be undermined if unlawful killing alone retained the criminal standard. And that's firstly because if unlawful killing alone retained the criminal standard, it would be necessary for the coroner to direct the jury to two different standards of proof in different parts of their conclusion. Beyond reasonable doubt when they do the unlawful killing part of it, and then balance of probabilities when they do everything else. It's an unwelcome additional layer of complexity. But in addition, the unlawful killing conclusion may be interrelated with other conclusions, and having the civil standard across the board avoids the prospect of different standards being applied to similar or interrelated conclusions. So, for example, a narrative conclusion may ask the jury to decide whether a particular matter was a failure, and they will apply the balance of probabilities to that. Then when they come to their unlawful killing conclusion, the jury may be asked to decide whether there was gross negligence manslaughter by that failure, and so whether there was a failure which was gross, but applying the criminal standard. So that opens the door for them finding that there both was and wasn't a failure, applying the different standards of proof. And so clarity and consistency both for the jury and for the wider public are better served by the civil standard across the board. The consequences of both a suicide and unlawful killing conclusion may be serious for those involved. But the consequences for unlawful killing are limited by a number of factors. So, firstly, the conclusion has no direct legal effect. It's not admissible as the truth of its contents in other proceedings. The inquest isn't penal and no one's liberty is at stake. The consequences are no more serious than those in a civil claim or care proceedings or before the parole board, where a finding to the effect that a serious criminal offence took place is made. And yet the balance of probabilities is still appropriate in those contexts. And so in my submission, it's not one of those exceptional cases identified in the REB line of authority, where the consequences are so serious as to justify the higher standard. It's also necessary to take into account the consequences for the family and public. See REB at paragraph 69. The family have a legitimate interest in the proceedings, and that's made clear from Middleton at paragraph 18. You were taken to paragraph 16 and 17 of Middleton, which encapsulate the court's conclusion that to satisfy Article 2, it's necessary for the inquest to culminate in an expression of the jury's conclusions on the important issues. At paragraph 18, which for your note is MS 923, Lord Bingham said that there are two considerations which fortify the correctness of that conclusion. Number one was that the family have a legitimate interest in the proceedings, and an uninformative jury conclusion is unlikely to meet their interests. So their interests need to be borne into account in deciding whether the consequences justify a civil or a criminal standard. In addition, the public have legitimate interests. They have an interest in being protected from future death and also from being informed about culpable conduct. See Amin at paragraph 31. And for the family and public, as I've submitted already, there may be serious adverse consequences of wrongly concluding that a killing was not unlawful. And there's no reason that the consequences for the suspect should outweigh those of the family and public. The Chief Coroner makes a number of submissions, and I'd like to turn to those now, please. Firstly, he made a number of submissions about suicide and set out, very fairly, the arguments in favour of there being a civil standard of proof for suicide. Now, if those are right, they apply equally, almost entirely, to unlawful killing, and they equally favour the standard of proof for unlawful killing being the civil standard. The Chief Coroner also refers to a range of prior authority on unlawful killing, which endorsed the criminal standard being applied to unlawful killing. I'd just like to briefly deal with that. The first case is McKirbin. McKirbin's reasoning was essentially as follows. Firstly, it recognised previous authority which said there's a sliding scale, that there's a higher standard in civil proceedings which is applied for more serious allegations. And Lord Justice Wolfe saw the force in the submission that standard, the civil standard, but the sliding scale, should apply at inquests. But he went on to say that there's likely to be no difference in practice to the outcome if the high civil standard is applied rather than the criminal standard being applied. And in order to ensure clarity when one is directing the jury, it's better to apply the simple criminal test rather than the more complicated sliding scale high civil test. Now, after the Re-B line of authority, that reasoning is no longer correct. It's no longer correct to say that there's a sliding scale or that there will be a high standard for serious allegations. It's no longer correct to say there'll be no difference in practice between the outcome of applying the civil standards and the criminal one. The fact of the difficulty directing a jury according to a sliding scale is no longer relevant. For the reasons I've already given, it's simpler if the civil standard is used across the board. The Chief Coroner mentions a number of other authorities at footnote 43 which endorse the criminal standard. None of those considered the Re-B approach. They essentially give two reasons for adopting the criminal standard, which are similar. The first is that a finding of unlawful killing essentially requires a determination that a crime was committed, or similarly, it requires the coroner and the jury to consider the same ingredients as would be considered in a criminal trial. And the second reason is a similar one, is that the public are likely to see an unlawful killing conclusion as a conclusion that an individual or a group of identified individuals were responsible for a criminal offence. Again, neither of those considerations survives the Re-B line of authority. So the fact that a serious criminal offence is being determined in care proceedings and civil proceedings before the parole board isn't sufficient to raise the standard of proof. The fact that exactly the same ingredients may be being applied by the parole board or in care proceedings isn't sufficient. And to give two specific examples, in Re-B, a finding, one of the factors at issue was whether a man had physically assaulted his daughter-in-law, and so that's a criminal offence, an offence of assault, and yet the civil standard was appropriate. In Re-D, the parole board case, one of the factors at issue was whether a man had sexually assaulted his niece, and again, the civil standard was appropriate to that. So the fact that the same ingredients as a criminal trial are being addressed isn't sufficient any longer to justify a higher standard. Similarly, in terms of public perception, a finding before a parole board of an offence of rape against a child has just as serious public perception as an unlawful killing conclusion. The Chief Coroner then sets out a number of reasons which may favour retaining the higher standard of proof for unlawful killing if the standard for suicide is dropped. And those are at paragraphs 56 to 63 of his submission. The first of them is he submits that, unlike all other verdicts in an inquest, unlawful killing isn't a simple finding of fact. It may connote a value judgment. And we submit that with respect that that's not correct. Unlawful killing may be a finding of fact. Take a case of murder where self-defence isn't raised. That would be come to if the jury are convinced that a person killed someone intending to do so or to cause them GBH. So those are findings of facts. Similarly, it doesn't work in the other direction. So there are a number of other conclusions that the inquest may come to which involve judgment. A narrative conclusion can be judgmental. The finding of gross failure in a neglect conclusion is just as judgmental as a finding of gross negligence manslaughter. The Chief Coroner moves on and refers to section 10.2 of the Coroners and Justice Act, so the prohibition on any determinations of criminal liability on the part of a named person. Now, in my submission, the Chief Coroner doesn't push it this far, but nothing in section 10.2a shows that Parliament intended that unlawful killing should have a high standard of proof to it. The Chief Coroner doesn't go that far, but it's difficult to see what the relevance of it is otherwise. And there's two reasons why I would say that. Firstly, a finding that a named individual committed a criminal offence would violate section 10.2a, regardless of what the standard of proof is applied. So even if the civil standard is applied, the finding would be a named person committed a criminal offence, and that would infringe that prohibition. And so the standard of proof doesn't have anything to do with section 10.2a. And so no inference can be drawn that Parliament intended a particular standard of proof should apply. But even if that's not right, at most what can be taken from section 10.2a is that Parliament contemplated that an inquest might apply the higher standard of proof to a criminal offence, not that it should do. It can't be taken as an indication that Parliament intended the higher standard should be applied. The Chief Coroner also referred to paragraph 8 of Schedule 1, which is the point about an inquest which is suspended and then resumed following criminal proceedings, and I don't have anything to add to the response that my Lord Reid made to that. The Chief Coroner discusses prosecution and notes that a prosecution may follow an inquest, and it's true, although the CPS, of course, makes its own independent decision on its own assessment of the evidence having regard to the differences between an inquest and a criminal trial, it's true that a prosecution may follow. But the same prospect of a prosecution occurs in civil proceedings. There's no material difference between the prospect. The Divisional Court recognised that following a finding of a serious criminal offence in a civil claim, the DPP may be expected to reconsider whether to bring a prosecution. And the case of the Crown on the application, the Crown against the DPP ex parte Treadaway, which is, for your note, MS 1374-5, came to the same conclusion. And so if the prospect of a prosecution in civil proceedings doesn't justify the higher standard of proof, it's difficult to see why it would in an inquest. So those are my submissions, unless there's anything I can assist you on further.
Could I ask a question? We haven't been educated about the availability of legal aid for the family and for those a person who is an interested person because he might have caused an unlawful act into which the jury and the coroner are inquiring. This admirable charity that helps the bereaved, particularly in relation to inquests, are more likely to be able to help us about the legal aid availability than anybody else. And in a word or two, what's the position?
Extremely limited. A family may obtain exceptional public funding under exceptional case funding for representation at an inquest if certain very limited criteria are met. And the main ones, the ones which the vast majority of funding is available under, are that, firstly, the Article 2 procedural duty is engaged, and secondly, public funding is likely to be necessary to enable the family to effectively participate in the inquest. But in practice, that means that the very great majority of inquests families attend without public funding.
And what about a person who's an interested person pursuant to section 47(2)(f), because he's a person who may, by any act or omission, have caused or contributed to the death?
Again, the short answer is it's exceptionally limited for that type of person. If it assists, we can provide a very short note showing the legislative provisions which are relevant to that, to give you more detail of the circumstances.
We'd appreciate that.
We'll provide that.
Well, thank you very much, Mr. Straw. We're very grateful to Inquest for their intervention and their assistance.
Thank you.
Ms. Monahan.
My lord, I've lost track of the time. I'm not sure whether we're 12:30 or 1, I'm afraid. I've got two different notes.
I think we're... You should be finishing about 20 to 1, I think.
My lord, that I'm quite confident I'll be finished well in time. Just a few observations, if I may. First of all, if I can hand up the 2013 rules, because they have the explanatory note. So you have the full rules, and you might want to just put that behind either tab 2, which are the rules, or tab 8, which are the explanatory memorandum, which is the explanatory memorandum. And so if you turn to the last page, just before the very end. And just two observations, if I may. New regime in paragraph 2, something we already saw in the explanatory memorandum. And rules set out the procedure. So the first paragraph will set out the procedure for managing proceedings and make provision for disclosure, provision relating to inquests heard with a jury. Last paragraph as well, part of a new package, I think we just said. And then if I may just point out one other matter, when the draftsman came to prepare this note, you'll see that he or she was very careful to say under explanatory note that this note does not form part of the order. And then please, I should like you, if I may, just to look at the Chief Coroner's guidance. This is for the purpose of easily getting through the history, and then I should like you to look, if I may, at some earlier provisions. So if I can ask you please to look at MS 2282, which is volume 6, tab 84, and then 2282. This doesn't, as your lordship's already elicited from Mr. Hoff, have any binding force, but it's a quick way into the history. So under historical perspective, precedents in the appendix to the first edition of Jervis in 1829 show that inquisitions at the time were in narrative form, explaining, for example, how the deceased, in manner and by means aforesaid, accidentally, casually and by misfortune came to his death by reference to the facts found. The origins of some short-form verdicts' conclusions are relatively recent. See, for example, unlawful killing. And C. Duggan. Section 4 of the Coroners Act 1843 had referred to a verdict of accidental death, but a list of short-form verdicts recognisable to modern-day coroners did not appear until the 53 rules. I will just in one moment take you to the 53 rules because we see the short form conclusions, or verdicts as they were then, and we can see that they are in the notes too, and thereafter that was the form adopted by coroners. At 15, however, a clear distinction had been made between circumstances and conclusions. Precedent for the form of inquisition described circumstances of the death as including facts over and above the medical cause, and one example was that CD did on the day of X fall into a pond, and so on. So the short point there, just to weigh in easily into the historical perspective, is that short form conclusions are relatively new, and as your lordships and your ladyship will see in one moment, they are found in the notes to the inquisition, not in the substance of the rules, as one might describe it. And we say that's indicative of the operative effect that they had, as indeed was well understood by the Chief Coroner when he prepared the guidance. If I can please take you to the 1953 rules separately. You've got the 1984 rules separately because Mr. Hoff handed them up to you. I should like you please to look at the 1953 rules, which I'm afraid, I hope you don't mind if Mr. Bunting just approaches you. I'm grateful. Thank you very much.
Thank you.
So we see at the penultimate page, the Inquisition, and we see there Inquisition, so bottom under paragraph 18, an Inquisition taken for our Sovereign Lady the Queen at X in the county, etc., on X date, before the coroner for the county and the jurors, if they're there, touching the death of the deceased, whose body has been viewed by me, etc. Following matters are found: name of deceased, injury or disease causing death, time, place and circumstances at or in which the injury was sustained, conclusion of the jury, particulars, and then signature, and then notes. So the form has in modern times always followed this form by notes, and then we turn over the page and we see the short form conclusions, and then the just above open verdict, so the fourth entry up from the bottom, we see what's now become unlawful killing, or lawful killing, forgive me, and then the various other short form conclusions, including killed himself, 3 or 4 up. So and murder there, moving upwards still. So we see that the origin of the short form verdicts derive from the notes to the rules. It has been assumed that these have been operative throughout, and the new form follows exactly this model, forms part of the rules and is intended so to do, because the explanatory notes tell us that what comes before forms part of the rules. And of course, it would have been easy for the draftsperson to put within the explanatory notes, which we now see in recent years, put in the explanatory notes what is understood by the standard of proof. That would be something for the court, if there were any ambiguity, to take into account. But nevertheless, it would be the right place to put any explanation as to understanding of the law, if that were thought helpful, but not sufficiently clear to put within the rules or the form. And relatedly, to pick up an observation, if I may, by Lord Carnworth, as to what the draftsperson might have understood when drafting the form and the notes, that is, can we assume that the draftsperson understood the law and was making any conscious reference to it in the notes. The answer is, in my submission, that these rules had a good deal of conscientious attention, and we see that, for example, by Rule 5.2, where it's clear that the draftsperson had in mind Middleton and so introduced the circumstances requirement in Section 5.2. So we see conscientious thought given to existing case law, and we see that reflected in the rules.
I mean, that's a statute.
That's a statute.
Is clearly reflecting Middleton. I don't think that's in dispute.
It is, and we see that reflected as well in the form where Section 5.2 applies. So there is a running through of what's required by way of conclusion, bearing in mind Middleton. That's reflected in the form, and we can assume that the draftsperson knew very well what the existing law was in relation to the standard of proof, because that's followed through in the notes, which, as history tells us, is expected to have some operative force.
But so far as narrative conclusions are concerned, they appear, I think, for the first time in the footnote, and the footnote tells us what standard of proof applies to those.
Yes.
How significant are the forms? How significant are the forms attached to the 1953 rules and the 1984 rules, since they are not required to be used?
They are intended to be the default position because they're there. What one can say is that it is the model adopted by the draftsperson, the model adopted, and when they came to revise the scheme, it was decided to ensure consistency and so on, these would become mandatory. So it was the same model. Notes tell the coroner what they ought to do, or what the default position would be. That's strengthened under the 2013 rules. So this is what you must now do, but following the same model of including within the form the notes. So we say model adopted, clear what was intended, short form verdicts permissible, not required but permissible, assumed to be the default position, may modify according to whether the inquest is held with or without a jury. It says, for example, in 53, delete in pursuance of statutory authority, and so on. The rules themselves require only that this may be used, but it's clear that it's anticipated that it will be used, hence the specific reference to the fact that it may be modified in certain circumstances. Assumption is the default position will be this is used. And that's strengthened by the draftsman in the most recent rules, no doubt mindful of the benefit of consistency so that everybody understands quite what's happening. The chief coroner, who's now there, can review what's happening, has a monitoring function under the statute, so can easily report because there is standardisation. I can see Mr. Hoff reassuringly nodding at this point, that the chief coroner, who has monitoring functions, can see across a series of standardised inquisitions quite what the position is, without the sort of inconsistency that one saw.
So would a record of an inquest which didn't follow Form 2 be of no effect in law?
Well, it would, in my submission, would be judicially reviewable. The question then would be what remedy would be available. So if it were a mere technical omission, and that does happen from time to time, there is an error in the way it's drafted, or there's some misunderstanding, then yes, it would be judicially reviewable. There would be a challenge. If it were a small technical error, I anticipate a High Court judge in the admin court would say, OK, we'll scrap that bit, or we'll amend it, or we'll get the spelling of the deceased's name right, as the case may be, or we'll ensure that the particulars are at least in the same form, if not in the same form, I mean by that in the relevant order and so on. But yes, it's required now to be in that form. If it isn't, it's breach of the rules, it violates the rules, and the remedy for that would be in the admin court. Although, of course, I anticipate a High Court judge wouldn't spend much time thinking about whether or not some small technical error should require a fresh inquest. Almost certainly not.
Yes, I only ask it because the word must is used by drafters in two senses, the mandatory sense and the directory sense.
May I, I beg your pardon?
Well,
I see, in general. In
yes,
general,
well, and it could be Rule 34, as I've got open.
Must make a determination using Form 2. And I beg your pardon, my lady. This
Well, simply that it will not result in a mandatory rule that you can only make a determination in this format, this form. I rather think that the reference to Form 2 is to the substance and not the form.
Well, using Form 2.
Yes.
And historically, certainly when one looks at the history as it's been understood as following the form as opposed to merely the substantive rules as we're describing them. Mm-hmm. Must make a determination and any findings. Certainly, and if one looks at Form 2, again, if I may, my lady, we see Form 2, record of an inquest. The following is the record of the inquest. So this is what is the formal record, the legal record. It records, as a matter of record, the matters that are required, including under the Births, Deaths and Registration Act 1953, not merely the verdicts or the narrative conclusions. So in my submission, read together, we can see that this is the form on which the verdicts and so on must be recorded. The form must be used as the record of inquest.
Well, your submission is that this is a mandatory requirement. Whether or not compliance in every technical detail would give rise to a judicial review, quashing is another matter. Be open to the judge to exercise his or her discretion, not to quash the finding. But prima facie, I should have thought that your argument is 34 is mandatory in terms.
Yes.
Yeah, and you showed us earlier how the previous rules had said may, and that word had been altered to must in 2013.
Been altered to must, and there was specific reference to the standard of proof in the knowledge, and we must assume the draftsperson knew the law. That's a matter of ordinary statutory construction. Must assume they knew the law. And again, I'm reassured that Mr. Hoff is nodding at least at that point as well. Do have some support from him. And drafted it accordingly with the requirement of must. And as I say, this was introduced as part of a package, including the Chief Coroner, who has monitoring functions, standardising the process, makes matters such as monitoring very much easier.
Can I ask in relation to that, the explanatory memorandum prepared by the government, which went before Parliament along with the statutory instrument, which we have in tab 8 of the black folder, effectively the equivalent of the old notes on clauses in relation to a bill. It tells us under paragraph 9 that, well, it doesn't tell us, it tells Parliament in paragraph 9 that guidance has been issued to coroners and local authorities on Part 1 of the 2009 Act and the new rules and regulations. Now, is that telling Parliament about the the rules which the guidance which the Chief Coroner issued, which we have in our bundles.
May I just ask Mr Hoff to help you with that? I'm grateful.
It's referring to, I think, to the Chief Coroner's Guide to the 2009 Act, which is a freestanding document separate from the numbered guidances, of which you have guidance number 17.
Well, we're told, I don't know if you have it in front of you, it says that guidance, I'll give you a moment to find it. You'll see at the top of the page, it says 9.1, guidance has been issued to coroners on Part 1 of the 2009 Act and the new rules and regulations. So it's slightly curious, but what it's telling us, or what it was telling Parliament, was that guidance on the new rules and regulations had been issued to coroners, and I'm wondering if that's the document that we have, the Chief Coroner's document.
It's not. We can certainly provide the court with the Chief Coroner's Guide to the 2009 Act.
No, that's not what I'm talking about. This explanatory memorandum was placed before Parliament, laid before Parliament, along with the rules that we are concerned with, the 2013 rules. So this has obviously been put before Parliament in 2013, along with the statutory instrument. And it tells us that guidance has been issued to coroners on the new rules and regulations. I'm wondering what it's... I thought it might refer to the guidance on the new rules that we have in our bundles, but if it doesn't refer to that, what does it refer to?
I believe, and I will have to check this and correct it if I'm wrong, but I believe it refers to this freestanding document, the Chief Coroner's Guide to the 2009 Act.
Right, so what's said in 9.1 is inaccurate. Is that what you're telling us?
Well,
It also refers to coroners and local authorities.
Mm-hmm.
Would the Chief Coroner be giving guidance to local authorities?
Well, local authorities provide the funding for coroners, so the guide would be of value to them too.
I think we ought to know, we need to know, I mean, if this is part of the material put before Parliament,
Yes.
before it approves these
exactly.
regulations, then
Yes.
we ought to know, because
I
it's probably part of the same package.
I shall check what this refers to, confirm whether it refers to the document I think it refers to, and I shall make sure that the court receives whatever it refers to.
Yes, I mean, it might, for all we know, it might refer to other guidance prepared by the department.
Yeah, I think we said now, I'd like to know. Because
Yes, we need to know, because obviously this is put before Parliament, and if anybody had wanted to inquire about this guidance, it'd be helpful for us to know what they would have found.
I will check the position and I'll put in a
Thank you very much.
note accompanied by whatever document.
Thank you.
Could I then just take Ms Maughan back to Rule 34?
Rule 34.
Yes, of the inquest rules, which is the one which we were examining a moment ago. The coroner, or in the case of an inquest heard with a jury, must make a determination, and so on. When we go back to, and any findings required under Section 10, when we go back to Section 10, there's no obligation imposed by primary legislation to make a determination in a prescribed form.
No, but there is, of course, my lady, the power to make rules.
Because there's nothing that I can see that says there's a power to prescribe forms. I know it's only, I'm just saying it's not there. I'm not saying it isn't included, but it's not there.
It's not, it doesn't find itself in
45.
In 10.
No.
It's save that, if I may say, save that, if particulars are required, oh no, that's not in the form, excuse me, I beg your pardon. Yes, so 10 just identifies what matters are to be found, and then 45 tells us that rules will be made for regulating practice and procedure.
Yes.
And in my submission, that would be wide enough to cover the procedure for
yes, but
ensuring
it doesn't
there's a record.
say it's got to be done in the prescribed form, which is a common formula. When we get to Rule 34, then, a coroner, or in the case of an inquest heard with the jury must make a determination in any findings required under Section 10. That is a replication of the statutory obligation in Section 10. And the words which follow, using Form 2, are not stipulated in the form of a mandatory rule. That's using Form 2. You've got to fulfil your statutory obligation, which is to carry out the determination which satisfies Section 10.
Yes.
Very important, but we've agreed not in a prescribed form. But when you get to Rule 34, it replicates the mandatory requirement in Section 10, and then merely adds the words using Form 2, which do not in themselves expressly create a mandatory rule.
In my submission, I would, if I may say so, say otherwise, submit otherwise.
Yes, I know,
forgive me,
so I'm
submit
asking.
Otherwise. A coroner, so mindful of the fact that the rules may make provision for the procedures that must be followed in an inquest, and then Rule 34 says must make the findings under Section 10 using Form 2. So it's Form 2 that is the prescribed means in my submission for ensuring that there's a record of an inquest addressing those
Thank you, it's
matters.
very helpful, thank you.
My lady.
Under the previous rules, when if I remember correctly, the form is the equivalent of Rule 34 is in the same terms, except must is may, and one wouldn't construe that as giving a discretion whether to comply with the statute.
No, I mean the
So and then ask oneself then, what's the purpose of changing may to must?
it's to use the form
So may must have been giving a permission not whether to comply with Section 10, but or its equivalent, but
not to use the form.
but whether to use the form.
Yes.
And if that's the correct reading of the may version of the rule, then the must version, one might think, was taking away that discretion relative
Precisely.
to the form.
That's, I was just going to say, it's perhaps odd then that Parliament, or the drafter of Rule 34, didn't say a coroner, or in the case of an inquest heard by a jury, the jury must make a determination in any of the findings required under Section 10 and must use Form 2.
Well, surely the must governs the use of Form 2. That's the natural reading of the rule, I should think. Because there's already an existing obligation under Section 10 to make a determination and to make findings. So it would be unusual for Rule 34 to be the vehicle by which the requirement to make the determination and the findings was given mandatory force. It must, I think, relate to the use of Form 2.
Well, in my submission, yes, and as we can, if I draw some, or I can draw some strength in relation to that from the fact that it had been may. So it wasn't just make the determinations that you're required to make under primary legislation, and then the form at the end that just there as a non-prescribed basis for doing so. It was a may, and there was a description of the circumstances in which it might be appropriate not to use the form in its full capacity. The rules were changed, introducing the mandatory requirement, that is a specific replacing of may with must, which one assumes, my lady, or I submit, must have meant something, we can assume there was some change meant by that. And if there was no must, or there was no reference to the form in Rule 34, then it would simply be repeating in terms precisely what was required by Section 10.
But one have to factor, obviously to think about it, one has to factor in that Parliament has not given authority in terms to prescribe a form which imposes yet another obligation on the coroner and his jury.
My lady, he's permitted the making of rules for the procedure that must be covered or adopted in relation to the conduct of the inquest, and the conduct of the inquest and its outcome includes the formal record, and the rules prescribe how the formal record will be created.
It might have been thought that it wasn't appropriate for procedural rules to lay down an obligation on coroners of that substantive nature.
Well, in my submission, it would be a procedural rule.
Yes.
The rules lay down things, for example, relating to disclosure.
Yeah.
One might say, well, disclosure is such an important matter, imposing an obligation on a coroner to ensure disclosure occurs in relation to interested persons. One might have thought such an important obligation, inquest to be heard in public. And this was an area that was highly controversial, as Mr. Hoff has said, because of the potential for holding inquests in private, particularly where there were national security issues. So provision had to be made for that. Entitlement to examine witnesses. Again, self-incrimination in a context of an inquest where an unlawful killing conclusion may result. So in my submission, those are also matters of considerable substance. And indeed, in my submission, the form issue, the mere form, might be considered to be much closer to a procedural provision than disclosure, cross-examination, hearing in public, self-incrimination, including in an unlawful killing hearing.
I should observe, I was mistakenly assuming in some remarks I made earlier that these rules were made by a Department of Government. They're actually made by the Lord Chief Justice.
Yes, they're made under the Constitutional Reform Act, and I think it's the Lord Chief Justice with the agreement of the Lord Chancellor. Right. So there are specific prescriptions under the Constitutional Reform Act, and they were made accordingly. So this was not a minister.
Yeah.
But the guidance is given by the Chief Coroner as an independent statutory agent, as it were.
Yes.
Not under the authority of the Lord Chief Justice in any sense.
No. No. The Chief Coroner is a statutory appointment. Yes. Yes. It's a statutory office, I should say. My Lords as well, just one final point, I think, and my lady, and that concerns, I think it's submitted by Mr. Hoff, and indeed I think as well by Mr. Straw, that there would be some tension between a requirement for intentionality in relation to a suicide conclusion beyond reasonable doubt and the making of observations or findings about failures that might engage Article 2 on a balance of probability. In my submission, there is no more tension than in relation to an unlawful killing conclusion. In relation to an unlawful killing conclusion, one will have to reach that conclusion beyond reasonable doubt, but one may still make findings in relation to state failures on balance of probability. So for example, a typical case, or typical for me, and not unusual in any event, will be a domestic homicide. So ex-partner pursuing his ex-partner and children, police informed regularly, she is ultimately killed, and the jury may well have to make findings of unlawful killing on an intentionality basis, as well as on the beyond reasonable doubt, as well as factual findings as to failure to protect, and on a balance of probability where intention may be very significant. Did this man intend to kill her? So whatever the police did, he would have found her eventually. So there are differences in relation to the standard of proof, in relation to parts of the conclusion, narrative and short, whether it's unlawful killing or suicide in my submission. And that's the jury's function, and that's the way they will be directed, normally in a complex case, through a route to conclusion, or a route to verdict, as it used to be called. And the jury's task is not an easy one in an inquest, but That's the way the state discharges its Article 2 obligations, among other things. I think I've reached my time. In fact, I think I'm probably 2 minutes over. I don't know.
We can excuse you 2 minutes, Mr. Maughan.
But the point, can I just say, the point that my Lord the President has made is very significant, isn't it? Because if you have legislation, as it were, or rules created not by a government department or a Minister of State, but by a judicial officer, you wouldn't expecting any policy issues to be determined in them, would you? Policy issues of changing the substantive law.
It's not, in my submission, it's not a change in the substantive law. It is a procedural rule that tells a coroner how it is they create a record, a formal record of the outcome of the inquest. And that's entirely a matter for, indeed it might be said, it's more a matter for a Chief Justice and the Lord Chancellor in terms of appropriateness. It's not a ministerial policy decision, shall we have hearings in public, which might be regarded as something more appropriate for a minister, but certainly a record of inquest is something that, in my submission, is...
Presumably you would say it's an authoritative statement of the law coming from the Lord Chief Justice and the Lord Chancellor.
Yes. And it's also approved through Parliament via the negative procedure. Mr. Bunting just reminds me, is that?
Yes.
Under the Constitutional Reform Act. So the rules are made as they are, and it still goes via Parliament through the negative resolution procedure. Appreciate the negative resolution procedure means that they probably didn't attract the scrutiny of the one that would see under the affirmative resolution procedure, but nevertheless, Parliament has the opportunity to intervene if they choose to do so.
So although it's the Chief Justice with the Lord Chancellor who makes them, they still go through Parliament under the negative. Negative. And I see from the notes this is the first time this procedure had ever been used.
There are, no doubt there was special attention paid then, my lord.
Fair point.
It is a judicial office holder making the rules in consultation.
Yeah.
I'm now 4 minutes over time.
Yes, yes, thank you very much, Ms. Monaghan. Council will have realised we found this a very interesting case, and it's obviously one of some importance. We're grateful to all who've made submissions and been involved in the preparation of the cases. We'll now take time to consider our decision.
Thank you.